The Judicial Committee hearing room was filled to the brim when Judge John Roberts let out a dismissive chuckle at Congresswoman Jasmine Crockett's questions. His laughter carried through the quiet chamber, surprising everyone present. "Congresswoman," he said, his tone dripping with superiority, "maybe these constitutional matters are best left to those with deeper legal knowledge." The room tensed at his pointed remark. Roberts leaned back in his chair, a smug grin tugging at his lips. That's when Crockett reached for a leather folder on the table in front of her. "Judge Roberts," she replied, her voice steady and firm, "before you challenge my qualifications, you might want to take a look at this." She slid a document across the table, stopping it right at the edge of his water glass. As Roberts glanced at the first few lines, his grin faded. His face paled under the bright committee room lights. In moments, the judge who had been chuckling was frozen, unable to respond as Crockett calmly dismantled not just his argument, but his entire judicial reputation in front of a stunned audience. If you enjoy videos where truth stands up to powerful figures, please like this video and subscribe to our channel for more. The tension between Congresswoman Jasmine Crockett and Judge John Roberts had been brewing long before their dramatic clash in the Washington, D.C. hearing room. They represented two very different views on America's legal system. One fighting for fairness and accountability, the other defending the traditional independence of judges at all costs. Jasmine Crockett had built a strong career tackling unfair systems within the law. A graduate of the University of Houston Law Center with top honors, she worked as a criminal defense lawyer before entering politics, seeing firsthand how court decisions impacted everyday people. Her election to Congress followed time in her state legislature, where she earned respect from both sides for her careful preparation and focus on meaningful legal changes. What set Crockett apart wasn't just her progressive ideas, but her sharp legal mind and ability to build solid cases with clear evidence. Judge John Roberts, appointed to the Federal District Court for the District of Columbia in 2017, was known for sticking to traditional legal views. With degrees from Princeton and Yale Law School, his credentials looked flawless. Before his judgeship, he served as a top lawyer for major companies and as a partner at a leading Washington law firm. His supporters praised his commitment to following the Constitution strictly, while critics pointed out his rulings often favored big businesses and government power over individual rights. Their paths crossed when the House Judiciary Committee began investigating troubling patterns in federal court sentencing. The committee's early report showed clear differences in how judges sentenced people for the same crimes, depending on the defendants' backgrounds. While not accusing anyone of deliberate unfairness, the data raised serious questions about possible unconscious bias in court decisions. Roberts became the loudest critic of this investigation, writing an article in a major newspaper calling it an attack on judicial freedom. He gave TV interviews describing the committee's work as sloppy analysis by politicians with agendas, not respecting the complexities of judicial decisions. Tensions grew when Roberts took the unusual step of filing a lawsuit to block the committee's request for sentencing data, arguing that Congress had no right to interfere with judges' work. Legal experts across political lines raised concerns about this bold resistance to congressional oversight. Roberts further escalated the situation by making public remarks about Crockett during a speech at a judicial conference, calling her a lawmaker who clearly didn't understand enough about the law to judge court decisions. This personal jab surprised even his supporters, as it broke the usual expectation that judges stay professional and reserved. What Roberts didn't know was that Crockett had been carefully gathering evidence about his own judicial actions. A whistleblower from the court's administrative office had given her documents showing concerning patterns in Roberts's sentencing decisions. Her team also uncovered records of financial ties between Roberts and companies that appeared in his court. Ties he was legally required to disclose and avoid under federal ethics rules. When the House Judiciary Committee scheduled hearings on judicial accountability, Roberts made the rare choice to testify, which many saw as a chance to publicly dismiss Congress's concerns and defend judicial independence. The hearing room was packed with reporters, legal experts, and staffers, expecting a tense but routine discussion about constitutional roles. No one could have predicted how thoroughly Crockett was prepared to challenge not just Roberts's arguments, but his personal and professional integrity with evidence he never expected to face in public. The hearing room in the Rayburn House office building was overflowing 30 minutes before the session began. Court reporters, Legal analysts, ethics experts, and curious staff filled the gallery, sensing a big moment was coming. Cameras were set up to capture every word. At exactly 10:00 a.m., Chairman Thompson called the hearing to order. The House Judiciary Committee's hearing on federal judicial accountability and transparency is now in session, he announced. After brief opening remarks affirming Congress's oversight role, he introduced the main witness. The committee welcomes Judge John Roberts of the Federal District Court for the District of Columbia. Roberts sat confidently at the witness table, his silver hair neatly combed, dressed in a sharp navy suit instead of judicial robes, a subtle signal he was appearing as an individual, not officially representing the courts. His opening statement was smooth and bold. Chairman Thompson, Ranking Member Davis, and committee members, thank you for this opportunity to address misunderstandings about judicial independence. The Constitution created 3 equal branches to prevent anyone from controlling the others. While Congress has oversight duties, this investigation into sentencing practices crosses a line by questioning judicial decisions without understanding their full context. For the first 40 minutes, committee members asked predictable questions about judicial accountability. Roberts gave polished but vague answers, emphasizing tradition and independence over transparency. The mood shifted when Chairman Thompson said, "The chair now recognizes the gentlewoman from Texas, Representative Crockett, for 5 minutes of questioning." Jasmine Crockett adjusted her microphone, her demeanor calm and professional, unlike some members who had been more confrontational. "Thank you, Mr. Chairman," she began. "Judge Roberts, I'd like to discuss the basis of your opposition to our committee's work. You've said publicly that Congress reviewing sentencing patterns is political interference by lawmakers who lack the legal knowledge to evaluate complex judicial decisions. Is that your position?" Roberts nodded, pleased to hear his words quoted. "Yes, Congresswoman, that's exactly my concern. Sentencing decisions involve detailed legal judgments that statistics often miss. And you believe members of Congress generally lack the legal knowledge to evaluate these matters properly?" Crockett asked. "With respect to the committee," Roberts replied, a hint of superiority in his tone, "most lawmakers don't have the specialized training or judicial experience to fully understand sentencing decisions." Crockett nodded thoughtfully. "Judge Roberts, before joining Congress, I practiced law for 15 years, including serving as lead counsel in over 200 criminal cases. I've worked with federal sentencing guidelines across multiple jurisdictions. Would you consider that relevant legal experience?" Roberts shifted slightly. "I'm sure you had a fine legal career, Congresswoman, but there's a big difference between advocacy and judging." "Indeed there is," Crockett agreed. "Just as there's a difference between respecting judicial independence and allowing judicial unaccountability. Judge Roberts, you've been vocal about our committee's statistical analysis of sentencing differences. In a recent interview, you called our methods fundamentally flawed and suggested we were picking cases to push a false narrative. Is that correct?" "Yes, and I stand by that," Roberts said confidently. "You also said any differences in sentencing could be explained by case-specific factors that our analysis ignored," Crockett continued. "Precisely," Roberts replied, a small smile forming. "Each case has unique elements that simple statistics miss." Crockett kept her tone even. "Judge Roberts, our committee worked with 3 independent statistical experts, including Dr. Margaret Chun from Harvard Law School's sentencing project. Are you suggesting Dr. Chun, who has published 37 peer-reviewed studies on federal sentencing, lacks the expertise to conduct proper analysis?" Roberts's smile faded. "I'm not familiar with Dr. Chun specifically," he began. "And would it surprise you," Crockett pressed, "to learn our analysis accounted for 27 case variables, including criminal history, cooperation with authorities, and offense details, the very factors you claim we ignored?" Roberts's expression tightened. "Congresswoman, no matter how detailed, statistical models can't capture the intangible factors judges consider. Let's move to your concerns about this committee's authority," Crockett said. "You've said repeatedly that congressional oversight of sentencing patterns violates the separation of powers and has no constitutional basis. You even filed a lawsuit to block our access to sentencing data on those grounds. Is that accurate?" "Yes," Roberts replied firmly. "I believe your committee has overstepped its constitutional authority." "And you consider yourself an expert on the constitutional limits of congressional power?" Crockett asked. "I've studied constitutional law extensively throughout my career," Roberts answered proudly. That's when Crockett's questioning took a sharp turn. "Judge Roberts, are you familiar with the Judicial Conduct and Disability Act of 1980? Roberts blinked, caught off guard. Of course, it sets procedures for complaints against federal judges. And the Ethics in Government Act, requiring financial disclosures from federal judges. Yes, naturally, he said, clearly wondering where this was going. Both laws were passed by Congress under its constitutional oversight authority, the same authority you claim we lack when examining sentencing patterns. Would you call those laws unconstitutional intrusions on judicial independence?" Roberts shifted uncomfortably. "Those are established laws with decades of precedent. Precedent that confirms Congress's constitutional authority to hold the judiciary accountable," Crockett said. "The very authority you're now challenging. Judge Roberts, I find it odd that someone so concerned about constitutional authority and legal expertise would make such basic errors in your lawsuit against this committee. Your lawsuit cited Anderson v. Trimble as a key precedent limiting congressional oversight of judicial functions. Are you aware of that case's history?" Roberts's confidence wavered. "I believe the Supreme Court upheld its core principle." "Actually," Crockett corrected calmly, "Anderson was overturned by the Supreme Court in 2018. Chief Justice Marshall's majority opinion specifically affirmed Congress's authority to collect and analyze judicial statistics for oversight. Exactly what our committee is doing. As a federal judge, citing an overturned case as precedent suggests either a lack of basic legal research or an attempt to mislead." The room went silent. Roberts's earlier confidence was gone. "Congresswoman, I believe you're mischaracterizing," he started, his voice shaky. "I'm not finished, Judge Roberts," Crockett said evenly. "You've questioned this committee's expertise and authority. Now I'd like to discuss your own judicial conduct." That's when Roberts made a critical mistake, trying to regain control. He chuckled dismissively. "Congresswoman, perhaps these constitutional matters are best left to those with deeper legal knowledge." His laughter echoed, startling several committee members. Chairman Thompson frowned but let the exchange continue. Crockett's expression didn't change as she reached for her leather folder. "Judge Roberts," she said, her voice calm but firm, "before you challenge my qualifications, you might want to look at this." She slid a document across the table, stopping it by his water glass. "This is a complete record of your sentencing decisions in drug possession cases over the past 5 years," she explained as Roberts scanned it. "Our analysis accounted for all relevant factors: criminal history, substance quantity, cooperation level, and 24 other variables. The data shows you sentenced black defendants to terms 41% longer than white defendants for nearly identical offenses, even when they had the same criminal history and defense counsel." Roberts's face paled as he turned to the second page. "More concerning," Crockett continued, sliding another document forward. "We've identified 12 cases where you failed to disclose conflicts of interest as required by judicial ethics rules. This spreadsheet details your undisclosed financial interest in Meridian Pharmaceuticals through a family trust. During that time, you presided over 6 cases involving Meridian, ruling in their favor each time without disclosing your financial tie or recusing yourself, as federal law requires." Roberts stared at the documents, his earlier arrogance gone. Crockett pulled out a third document. "Finally, we have communications between you and 3 other federal judges discussing ways to resist congressional oversight. These directly contradict your sworn testimony last year that no such coordination was happening." Roberts's voice, when he finally spoke, was barely audible. "These seem to be private communications. I'm not sure how you obtained them. They were provided through legal channels by individuals concerned about judicial integrity," Crockett replied. "Their authenticity has been verified through metadata analysis." She looked at him directly. "Judge Roberts, you've questioned this committee's expertise, authority, and motives. You've personally challenged my qualifications. Yet the evidence shows you've consistently violated the ethical standards and legal requirements you swore to uphold." The 5-minute timer beeped, but Chairman Thompson said, "The gentlewoman from Texas is granted an additional 3 minutes." Crockett nodded. "Judge Roberts, I have 3 questions. First, do you dispute the statistical analysis showing racial disparities in your sentencing?" Roberts glanced at his lawyer, who stared at his notepad. "I'd need to review the methodology more thoroughly," he said weakly. "Second, do you acknowledge failing to disclose your financial interest in Meridian Pharmaceuticals while presiding over their cases?" "The trust is managed independently," Roberts began. Federal rules require reporting interests held through family trusts above the threshold, which these did, Crockett corrected. Do you acknowledge failing to disclose is required? After a long pause, Roberts said, there may have been an administrative oversight in my filings. Third, do you deny coordinating with other judges to resist oversight after testifying no such coordination occurred? The room was silent. Roberts stared at the document, then whispered, I'd like to consult with counsel before answering further. Chairman Thompson spoke up. Judge Roberts, this committee has already sent these materials to the Judicial Conference's Committee on Judicial Conduct and the Department of Justice's Public Integrity section for review. We can recess for you to confer with counsel. As he called a 15-minute break, the room buzzed with murmurs. Reporters rushed out to file stories. Crockett calmly organized her papers while committee members examined the evidence. In 8 minutes, a routine hearing had become a historic moment of judicial accountability. Judge Roberts, who had entered with confidence, now sat pale and silent, undone by his own documented actions, presented by a congresswoman whose legal expertise he had underestimated. When the hearing resumed, the atmosphere had changed completely. News of the confrontation had spread, and more reporters and even senators not on the committee squeezed into the gallery. Roberts returned, looking shaken, with his attorney close by, whispering advice. His hands trembled as he arranged his notes. Chairman Thompson spoke solemnly. This hearing will resume. Judge Roberts wishes to make a statement. Roberts leaned to the microphone, his voice unsteady. Mr. Chairman, in light of the documents presented by Representative Crockett, I believe it's appropriate to recuse myself from any litigation concerning this committee's investigation. Additionally, he paused, glancing at his attorney, I am requesting a temporary leave of absence from my judicial duties pending review of these matters. The room felt the weight of his words. A federal judge stepping back during testimony was unprecedented. Chairman Thompson nodded. Your statement is noted. The committee appreciates your recognition of these concerns. He turned to Crockett. Representative Crockett, you have 2 minutes remaining. Crockett, still composed, spoke without triumph. Thank you, Mr. Chairman. Judge Roberts, this committee's purpose isn't to target individuals, but to ensure the judiciary upholds the highest ethical standards. The evidence today suggests systemic issues needing structural solutions. Would you agree that enhanced transparency and accountability could prevent similar situations? The question offered Roberts a chance to respond constructively. After consulting his attorney, he said cautiously, Congresswoman, while judicial independence is essential, I acknowledge accountability is vital for public trust. I'd be willing to provide written recommendations for improving ethics enforcement. Crockett nodded. I appreciate that. My final question is about the broader implications. You've served on judicial education committees and spoken on ethics. What message do today's revelations send to other judges with undisclosed conflicts or who resist oversight? Roberts reflected, then answered with surprising honesty. It shows the judicial oath matters, and accountability strengthens, not weakens, judicial independence. No judge should consider themselves above ethical requirements or congressional oversight. With that, Crockett's questioning ended. Other members followed, but the decisive moment had passed. By noon, news networks broke in with headlines. Federal judge steps down during hearing after evidence of ethical violations. Outside, reporters swarmed Crockett. How long have you been gathering this evidence? Will you push for ethics charges? Did you expect his leave of absence? She raised a hand for quiet. I'll make a brief statement, but I won't discuss specific documents now. Today's hearing showed both the challenge and promise of our system. The challenge is ensuring power, judicial, legislative, or executive, stays accountable. The promise is that evidence and facts can overcome position and privilege when our institutions work right. The evidence reveals concerning patterns beyond any one judge. When those entrusted with the law fail to follow it, public trust in the system suffers. Judge Roberts's decision to step back reflects appropriate recognition of these issues. This hearing was never about politics or targeting individuals. Our goal is constructive reform to strengthen the judiciary through transparency and accountability. As she headed to the elevators, her professional confidence showed this was a carefully planned effort to address systemic issues with evidence, not rhetoric. By evening, the impact had grown far beyond one judge. The Judicial Conference announced an emergency task force on ethics enforcement. The Department of Justice confirmed a review of the financial disclosure issues. Legal analysts struggled to capture the moment's historic nature. Professor Elena Montgomery from Harvard Law School said, "What made this hearing extraordinary was how Representative Crockett used documented evidence of specific ethical violations, not political attacks, to shift the power dynamic between Congress and the judiciary." The American Bar Association acknowledged concerns about current ethics enforcement and called for a thorough review of how conflicts are handled. Judge William Henderson, Roberts' superior, issued a statement. "The matters raised today are serious and require investigation. I've accepted Judge Roberts' leave request and ordered a review of all cases mentioned in Representative Crockett's documents. The court is committed to ethical conduct and transparency." For Crockett, the day marked a shift from respected lawmaker to a national advocate for judicial accountability. Her office received messages from legal experts, reform advocates, and judges praising her methodical approach. Rather than using partisan attacks, she had compiled clear evidence and let it speak for itself, changing the debate about judicial accountability. In the months that followed, the impact reshaped the judicial system. 2 weeks later, Roberts resigned, citing personal reasons, but the timing pointed to the hearing's fallout. The Judicial Conduct Committee found additional ethical issues. The Federal Judicial Center launched a review of disclosure and conflict procedures. Chief Justice Williams ordered an audit of cases involving major companies across federal courts to uncover similar issues. Crockett and the committee saw their methods adopted nationwide. Law schools added their analytical approach to ethics courses, recognizing that data could reveal problems missed by individual case reviews. 6 weeks later, the American Bar Association held a symposium on judicial ethics, with Crockett delivering the keynote. "That hearing wasn't about one judge or committee," she said. "It was about balancing judicial independence and accountability. We've acted as if accountability weakens independence, but true independence requires ethical integrity." Her words earned praise across ideological lines. Judge William Pryor noted, "Crockett's focus on documented patterns provides a template for oversight that strengthens judicial legitimacy." Reforms took shape quickly. The Judicial Conference updated disclosure requirements, adding automated checks of judges' financial interests against case parties. New software flagged potential conflicts before case assignments. Congress passed a Judicial Transparency and Ethics Enforcement Act with bipartisan support, creating an independent inspector general for the judiciary, something long resisted. The law balanced independence with accountability, incorporating input from judges and scholars. At the signing ceremony, the president said, "This bill shows our system at its best, strengthening all branches by ensuring public trust in our courts." The confrontation's legacy reached legal education. Harvard Law School created a Center for Judicial Ethics and Accountability to research best practices. Its first conference focused on using data for ethical oversight. Judge David Martinez, speaking at a circuit conference, said, "We've treated ethical rules as technicalities, not safeguards. Recent events remind us our authority rests on public trust, which requires visible compliance." Legal journals validated the committee's methods. A Columbia Law Review article called the approach a new paradigm for oversight, praising its systematic use of data. 8 months later, the Department of Justice confirmed systematic sentencing disparities and undisclosed conflicts in multiple courts, leading to case reviews. The Federal Public Defender's Office created a unit to examine potential bias, offering justice to defendants. The confrontation reshaped how branches interact, showing oversight could work without crisis, using evidence and preparation. Future investigations adopted the Crockett methodology, prioritizing facts over posturing. On the hearing's 1-year anniversary, Georgetown Law Center hosted a symposium, Ethical Oversight After Roberts. Crockett reflected, "A year ago, Judge Roberts laughed at Congress's ability to evaluate judicial conduct. That laugh reflected an arrogance that had grown over decades. The idea judges were above accountability. Today, we've built a system that strengthens the judiciary through consistent, transparent ethical standards. True independence means applying the law fairly, without fear or favor." For the public, the confrontation raised concerns about hidden issues, but renewed hope in accountability. Letters to Crockett's office expressed worry about what might have stayed hidden and faith in oversight. Judge Sonia Wilson, Roberts' replacement, said during her confirmation, "Our judicial system's strength isn't in pretending judges are perfect, but in correcting course when issues arise. Accountability and independence work together." For Crockett, the aftermath brought recognition and responsibility. Law schools sought her expertise, and judicial conferences valued her insights. Her focus on facts over ideology bridged divides. At the American Constitution Society's convention, she said, "The strongest accountability tool isn't anger or moralizing. It's clear documentation of facts that can't be ignored. When faced with their own actions, even powerful institutions must act or lose legitimacy." The story of Crockett and Roberts became a case study in how democracy adapts when accountability works, not through conflict alone, but through evidence that makes denial impossible. If you found this story of integrity and accountability inspiring, please like and subscribe for more content on truth prevailing over power. In a democracy, no position is above accountability, and preparation and evidence are our best tools against institutional misconduct.